Well, that's an interesting question because the law changed just recently on January 1st of 2021. Prior to January 1st, 2021, there was a three-tiered exemption structure for exempting the principal residence of a debtor. And let's just focus on Chapter 7 because we've already talked about how this plays out in a Chapter 11 or a Chapter 13. But on January 1st, a new law went into effect in the homeowners table. You may remember I said there are two tables in California, one for homeowners with equity, the other for everybody else. Now, the exemption on a person's principal residence, now you can't use this on other real estate, it must be your principal residence, is minimum $300,000 in equity, up to a maximum of $600,000, and it is determined by what the median price is for a house in your particular county. So I'm in Los Angeles County, and I serve primarily Los Angeles and Orange counties, and also to a lesser extent, Riverside County. Both Orange County and Los Angeles County have median house prices of over $600,000. So what that shows is that the exemption is $600,000. But there are a couple of caveats here. First, what you're exempting is not the value of the house. What you're exempting is the value of the portion of the house that you actually own, the equity. So what we do is we start with the market value of the house. From that, we subtract out the amount you still owe. What's left over is the equity. That's what you have to exempt. So unless your house is paid off, the chances are the equity is going to be under $600,000. But there's a second wrinkle, and this takes us to the bankruptcy code. Remember, that's a federal statute, and California has opted out of the exemptions in Section 522 of the bankruptcy code. But there is a provision in Section 522P that says if you have not had the house for at least 1,215 days, then you don't get your state's exemption. Instead, you get a maximum of $170,350 in exemption on the equity in your house. Well, what is 1,215 days? Well, if you do a little bit of arithmetic, it turns out that is 3 years and 4 30-day months. So if you've lived in the house for less time than that and you have more, $170,350 in equity, we'll probably want to postpone filing your bankruptcy papers until you get past that 1,215-day mark. And then we can exempt the entire equity, because then, of course, you've got the $600,000 as the cutoff. Now, this is not a retroactive provision. If you filed a bankruptcy case before January 1st, then you're under the old three-tiered scheme, and that was much more parsimonious than the very generous exemption structure that we have now. So occasionally I'll have somebody pose the question, well, wait a minute, I filed in December. Now that the exemption has gone up, do I get to use the higher exemption? And the answer is no. In fact, there is Ninth Circuit case law holding that the exemption is fixed on the petition date, the date you file your bankruptcy petition. So you don't get to update the exemption after you've filed the bankruptcy papers. As a result, the filing needs to be done carefully. Timing, as in so many things in life, is absolutely essential in filing a bankruptcy case.